I'm Gary Davidson, and I have the real estate group here at Castle Law. Earnest money. What is it? And what kind of money should we be using? And what's it for? How do we obtain it if someone breaches a contract? So earnest money in general is posted by a buyer within the first few days of a contract being executed, and it literally expresses their earnest intent to buy a property. Generally speaking, we are seeing anywhere from $1,000 to $10,000 of earnest money being put down. With most often, we see anywhere from $1,000 to $5,000 in earnest money. Now, earnest money is held by an escrowee for the benefit of the parties. What's an escrowee? That's typically going to be a real estate company, an attorney's office, or a title company. So the borrower will make a check payable to that company, and it is held for the mutual benefit of the parties. That provides the consideration to make the contract effective. If earnest money is not tendered within the time frame, there isn't a valid contract. Once the closing gets scheduled, the earnest money is sent to the title company, and that money is credited against the amount of money the buyer needs to bring in order to buy the home. Under what circumstances is earnest money forfeited to a seller? There are a number of provisions in a contract where, in the event they're not satisfied, a buyer has a right to return of their earnest money. Attorney review, home inspection, mortgage contingency are the three main ones. If during the first 5 days of a contract, either attorney has an opportunity to disapprove of the contract, and at that time the contract's null and void and the earnest money is refundable. Similarly, if the parties cannot reach an agreement during a home inspection, the parties can't come to terms, earnest money would then be refundable. On transactions where a mortgage is involved, if the party does not receive a loan approval and the loan approval is denied within that mortgage contingency period, the earnest money would then again be refundable. Now, if a buyer or a seller breach a contract, the escrowee, that's the real estate company, the title company, the attorney's office, they don't have the right to unilaterally determine who gets that earnest money. If both parties sign off that the earnest money is released to either party or some compromise is reached, the escrowee has the authority to release the escrow money. Beyond that, the parties would need to file a lawsuit against the other party, and a judge would determine who is responsible for turning the earnest money over to the other party. Most contracts have very specific terms on how earnest money can be released, and you should reference your specific contract. Further, most contracts will have a provision that says that in the event a suit is filed to recover earnest money, the prevailing party will receive their attorney fees. For additional questions regarding earnest money or any other real estate related matter, please contact us here at Castle Law.